Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. On May 14th, 2026, the Supreme Court stepped into one of the most explosive fights since Dobbs, Danco Laboratories versus Louisiana.
It's emergency docket season. 7 justices voted to block the Fifth Circuit's order that reinstated in-person dispensing requirements for Mifepristone, the leading abortion drug in the country. The court issued an unsigned order with no reasoning. Justice Thomas and Justice Alito each filed solo dissents. Thomas labeled Mifepristone distribution a criminal enterprise. Alito called the court's order remarkable and unreasoned. Bottom line, mail order Mifepristone stays legal for now, while the merits fight rages on.
Before going further, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you got questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know.
Let's rewind 26 years. The FDA first approves Mifepristone for medication abortion in 2000 and slapped heavy restrictions on it, something called a REMS, a risk evaluation and mitigation strategy. Think of it like a super warning label. The drug carried a black box warning, the most severe warning the FDA puts on any drug, flagging serious and sometimes fatal infections and bleeding. And one of the biggest restrictions, you could only get it in person, at a clinic or hospital. No pharmacies, no mail order.
Fast forward to 2020, COVID hits. A federal court temporarily blocked the in-person requirement during the pandemic. The FDA watched what happened. No safety spikes. And in April 2021, the FDA stopped enforcing the in-person rule entirely. Then came Dobbs in June 2022, which returned abortion regulation to the states. That very same day, President Biden announced his administration would use every lever to protect access to medication abortion, specifically promising that Mifepristone would remain as widely accessible as possible, including by mail. Louisiana, which banned nearly all abortions after Dobbs, quickly became ground zero for the fight that followed.
Here's the kicker. Despite Louisiana's ban, approximately 1,000 Mifepristone-induced abortions started happening in the state every single month, more than before Dobbs. How? Doctors in states like New York and California started prescribing Mifepristone through telehealth and mailing it directly to Louisiana women, and those states passed what they called shield laws, statutes that blocked Louisiana from arresting or prosecuting the out-of-state doctors.
And this created real human consequences. Take Rosalie Markizich, one of the named plaintiffs. She didn't want an abortion. She told her then boyfriend she wanted to keep the baby. He went online, filled out a form with her information, paid a California doctor through Venmo, and got Mifepristone mailed to their Louisiana home. She pleaded, "Don't make me do this." But he grew angry and erratic. Terrified, she took the pills in front of him. She ended up on a bathroom floor bleeding for about a week.
Then there's the story of Dr. Margaret Carpenter, a New York doctor who mailed Mifepristone to a Louisiana woman. That woman forced the drug on her pregnant teenage daughter. The teen delivered a dead fetus alone at home after calling 911. Louisiana issued an arrest warrant for Dr. Carpenter. New York Governor Kathy Hochul responded, "We will never comply with Louisiana's extradition request. Not now, not ever."
So, Louisiana took a different path. They sued the FDA in the Western District of Louisiana under the Administrative Procedure Act, the APA, which governs how federal agencies make rules. Louisiana argued the FDA acted arbitrarily and capriciously when it stripped away the in-person dispensing requirement in the 2023 REMS.
The district court, in a fascinating decision on April 7th, 2026, found that Louisiana likely would succeed on the merits and suffered irreparable harm, but then it denied the requested relief anyway. The judge concluded the balance of equities favored letting the FDA finish an ongoing safety review rather than disrupting a nationwide regulatory regime. The court stayed the case and told the FDA to report back within 6 months.
Louisiana didn't wait. They appealed to the Fifth Circuit, and on May 1st, 2026, just 24 days later, a 3-judge panel granted the stay. Judges Southwick, Duncan, and Engelhardt suspended the 2023 REMS changes nationwide, effectively reinstating the in-person dispensing requirement. and they refused to give the manufacturers even a 7-day window to adjust. The next day, both manufacturers, Danco and GenBio Pro, filed emergency stay applications at the Supreme Court, presenting them to Justice Alito as the Circuit Justice for the Fifth Circuit. The FDA, and this part stunned everyone, took no position. The federal agency whose own rule sat at the center of this fight refused to defend it or oppose the stay. Just silence.
Okay, so let's unpack the legal question. When someone asks the Supreme Court to stay a lower court order, the court looks at 4 factors. Likelihood the court would eventually grant review and reverse, irreparable harm to the applicant, balance of equities between the parties, and the public interest. And here's where the battle lines crystallized. The manufacturers built their case on Article 3 standing, which basically means you need to show the court why this fight affects you personally. They argued Louisiana faces zero direct regulation under the 2023 REMS. Louisiana doesn't prescribe Mifepristone. Nobody told Louisiana to do anything or stop doing anything.
In normal person language, the manufacturers told Louisiana, "You're complaining about somebody else's mail."
Exactly. And they pointed to 2 unanimous Supreme Court decisions. First, FDA versus Alliance for Hippocratic Medicine. That's the 2024 case, where every single justice agreed that anti-abortion doctors lacked standing to challenge the Mifepristone REMS because the chain of causation stretched too far. A doctor can't sue the FDA just because more patients might show up at emergency rooms. Second, United States versus Texas, 2023, where the court rejected states' claims that federal immigration policies cause them indirect costs. The majority said downstream spending doesn't automatically equal a legally and judicially cognizable injury.
Louisiana punched back hard. Their argument started with sovereignty. They cited Vermont Agency of Natural Resources versus United States ex rel. Stevens, a 2000 case, for the principle that a violation of a sovereign's laws constitutes an injury to that sovereign's sovereignty. Period. 1,000 violations every month, each one a concrete, particularized sovereign injury.
And Louisiana added a second layer. They can't even enforce their own laws. With the in-person requirement gone, out-of-state doctors mail Mifepristone from jurisdictions whose shield laws make Louisiana powerless to arrest or extradite anyone. Louisiana invoked Cameron versus EMW Women's Surgical Center, a 2022 case, holding that a state clearly holds a legitimate interest in the continued enforceability of its own statutes. Without the in-person rule, Louisiana's abortion ban functions as, to borrow their phrase, parchment promises.
And on top of the sovereign injury, Louisiana presented pocketbook harm. Over $92,000 in Medicaid costs from just 2 emergency hospitalizations. Over $17,000 in investigatory costs from just 3 cases. They argued these costs tie directly to the sovereign injury. They don't float independently. Louisiana called this one of the most obvious standing claims this court should ever see.
Now, on the merits, whether the FDA acted arbitrarily and capriciously, the manufacturers pointed to 15 studies covering 55,000 patients, all supporting the safety of mail-order Mifepristone. But Louisiana fired back with a devastating attack on the data. The FDA eliminated the requirement for prescribers to report non-fatal adverse events in 2016, then in 2023, relied on the resulting absence of adverse event reports to justify removing the in-person rule. 3 separate Fifth Circuit panels called this an ostrich's head-in-the-sand approach.
Think of it this way. Imagine a school eliminates its fire alarm system, then 3 years later announces, "Good news. No fire alarms went off." So clearly, the building doesn't need fire safety equipment. That captures the core of Louisiana's APA argument.
And the FDA's own admissions kept making things worse. Secretary Kennedy stated the Biden administration removed Mifepristone's in-person dispensing rule without studying the safety risks. The FDA conceded the 2023 REMS reflected a lack of adequate consideration. And the FDA commissioner reportedly told agency officials to delay the safety review until after the midterm elections.
So after all that, after 80-plus pages of briefing from each side, after the district court, after the Fifth Circuit, after the FDA's conspicuous silence, what did the Supreme Court actually do?
It granted the stay applications in a single paragraph. No reasoning, no analysis of the 4 stay factors, no explanation of whether it credited the manufacturer's standing arguments or Louisiana's sovereignty claims. Just, the Fifth Circuit's order now stands blocked pending further proceedings. And that absence of reasoning drew fire from both dissenters. Let's start with Justice Thomas. He went nuclear. Thomas argued that the manufacturers derive their claimed injury from profits they earn through what he called a criminal enterprise, violating the Comstock Act. That's 18 U.S.C. sections 1461 and 1462, the Civil War-era statutes banning the mailing of drugs designed to produce abortion. Thomas stated flatly, all of this violates the Comstock Act. He argued no court exercising equitable power should protect lost profits flowing from federal felonies.
Thomas compared the stay application to asking a court, please protect our revenue from our crime. He cited Zedner versus United States, a 2006 case, for the principle that reducing someone's opportunity to commit crimes serves the public interest. It therefore can't count as an irreparable harm. Not exactly subtle.
Then, Justice Alito wrote separately, his dissent ran much longer and built a layered argument that the manufacturers failed to demonstrate irreparable injury, the threshold requirement for any stay.
Alito made 7 distinct points. First, the FDA won't enforce the old rules anyway. The agency already declined to enforce the in-person requirement for 2 years before the 2023 changes and currently wants to maintain that non-enforcement posture. Second, the manufacturers barely tried to show harm. They devoted only 3 of their 80-plus pages to irreparable injury. Third, regulatory uncertainty alone falls short. Restoring the pre-2023 REMS simply brings back rules the manufacturers operated under for years. Fourth, lost sales in states banning abortion don't count as irreparable injury because equity demands surrender of profits from unlawful activity. He cited Liu versus SEC 2020 and United States versus United Liquor Corporation 1956, where a justice denied a stay when the alleged injury flowed from inability to participate in an unlawful conspiracy.
Alito also framed the entire controversy as what he called a scheme to undermine Dobbs. He traced the chain from President Biden's executive orders through the FDA's rule change through the SHIELD laws, painting a coordinated effort to nullify state sovereignty. That framing carries enormous weight because Alito authored Dobbs itself.
Okay, time for our What This Actually Means segment. So what actually changes after this decision?
Right now, for patients, pharmacies, doctors, and manufacturers, nothing changes immediately. The court's stay keeps the 2023 REMS in effect. Telehealth prescriptions continue. Mail order delivery continues. Pharmacy dispensing continues. The status quo holds. But underneath that stability, a time bomb keeps ticking. The Fifth Circuit appeal continues. If the Fifth Circuit rules for Louisiana on the merits, we bounce right back to the Supreme Court on a certiorari petition. And Louisiana's response brief offered to acquiesce in certiorari before judgment with argument before the summer recess, meaning both sides expected this dispute to return quickly.
The standing question alone could seriously alter administrative law. If states can establish Article 3 injury through violations of state law caused by federal regulatory loosening, that opens the courthouse door to challenges against virtually any deregulatory action. Drug approvals, environmental rollbacks, immigration enforcement decisions.
And Thomas's Comstock Act argument, that looms like a shadow over the entire pharmaceutical industry. If a single justice views existing federal law as criminalizing mail-order Mifepristone distribution regardless of FDA approval, that question will surface again and again.
Meanwhile, the FDA's silence speaks volumes. The federal agency responsible for drug safety declined to defend its own rule. Secretary Kennedy admitted the rule lacked adequate consideration. The commissioner reportedly delayed the safety review for political reasons. That credibility gap gives Louisiana ammunition in every future proceeding.
So here's the bottom line. The Supreme Court kept the lights on for mail-order Mifepristone, but 7 justices did it silently, offering no roadmap. The fight over standing, the APA challenge, the Comstock Act, and the federalism collision, all of that lives to fight another day, and it will. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you got questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And seriously, tell a friend about the show. Tell a colleague. Tell your dog. Tell the person sitting next to you on the train.
Tell your dog?
Dogs love constitutional law. Everybody knows that.
Fair enough. Hit that subscribe button. Talk to you soon.